Hello and welcome. This is part of our series of videos on proposed amendments to the ICSID rules. This video will look at the topic of transparency under the ICSID arbitration rules. The working paper on amendments discusses this in detail under Arbitration Rules 44 to 49, Additional Facility Arbitration Rules 54 to 58, and in Schedule 8.
When you consider these rules, it's important first to remember the context. States are able to provide for different transparency provisions, perhaps lesser or greater transparency provisions, in their treaties, contracts, and laws. In addition, if two states are signatories of the Mauritius Convention, that may also affect the transparency provisions that apply in any given case. So what we are really looking at here is where states have not made treaty-specific provisions. So you can think of these ICSID transparency rules somewhat as a baseline where no other rules apply to transparency of a case.
There are a number of aspects to transparency. First, there are obligations on ICSID as an administering institution. For example, ICSID publishes lists of member states, panel designations, notifications, and courts for enforcement. It also publishes information about the Center and about individual cases in accordance with the rules applied to each case. Second, there are several rules particularly applicable to tribunals and ad hoc committees. They must deliberate in private, and deliberations remain confidential. Third, there are rules directed to the arbitration proceedings themselves and to the publication of awards, decisions, and orders. Arbitration awards issued under the ICSID Convention are addressed slightly differently than arbitration awards issued under the ICSID Additional Facility Rules. This is because Article 48.5 of the ICSID Convention states, "The Center shall not publish the award without the consent of the parties." Proposed Rule 44 states that an award will not be published without consent, but also would deem consent to publication unless a written objection is received from a disputing party within 60 days. If a party does object, legal extracts of the award would be published, as is the case today. Awards under the Additional Facility Arbitration Rules and decisions and orders under both sets of arbitration rules would be published within 60 days of being issued. They could be published with redactions jointly agreed by the parties. If the parties, however, cannot agree on redactions, the tribunal would decide on redaction, and ICSID would then publish the decision or order. Other documents, for example, memorials or witness statements, could also be published with agreed-upon redactions. Hearings would be open to the public unless either party objects, and the tribunal will take any necessary steps to ensure confidential information is protected if the hearing is open to the public.
The proposed rules on transparency also deal with participation by a third party, and they deal with this in two rules. First of all, on non-disputing party participation, and secondly, a new rule on non-disputing treaty party participation. The process to apply to be a non-disputing party continues to be a two-step process. First, the non-disputing party asks for permission to file a non-disputing party submission. To get such permission, it must meet the test in Article 48, Sub 2. That means that it has to show that its submission is in the scope of the dispute, that it will assist the tribunal on a factual or legal matter that is relevant to the case, or that it brings some kind of a new insight to the case. New rules also add two other criteria. First of all, that the non-disputing party is well identified, including its affiliation to either disputing party. And second, that the non-disputing party has to advise if it's receiving any assistance to file a submission. Parties continue to be entitled to make submissions on whether there should be a non-disputing party submission in the first place, and if so, what the conditions for a non-disputing party submission would be. These could include things like conditions on the format or length of the submission. One new aspect of the proposed rules is that a tribunal would have discretion to condition non-disputing party submissions on contribution to costs of the overall case. In addition, the tribunal would be entitled to provide access to documents in the case to the non-disputing party unless a disputing party objects.
A new rule is proposed for non-disputing treaty party participation. This rule would give a non-disputing treaty party the right to make a written submission on a question of interpretation or application of the treaty. But the non-disputing treaty party must apply under the non-disputing party rule for permission to make a submission on any question beyond the interpretation or application of the treaty.
We hope that this helps you understand the transparency regime that's proposed for the new ICSID rules. If you have any details that you want to look up, please take a look at the working paper and in particular the schedule on transparency. We look forward to any comments that you have. Thank you.